Thank you very much, Data, and welcome everyone to this session on multi-state tax issues for payroll for 2016. We've got quite a bit of ground to cover today, and so we'll be moving fairly quickly through the slides. First of all, we're going to talk about Nexus and why that's important, what it is and why it's important. We'll take a look at state income tax, which is probably the primary thing that we're concerned with in this session. In state income tax, the general rules regarding whether to withhold or whether somebody's subject to income tax and so on. Reciprocal agreements, withholding certificates, supplemental wages, fringe benefits, and some other reporting issues. We'll take a look at state unemployment tax, and a new addition that I didn't list specifically on there, but it's under special issues, is paid sick time. And there are some requirements that are coming into play there. Starting off with Nexus, this means a connection, and in the business sense, for businesses, it means a business presence, office, store, factory, or some other kind of operations within the state. The main issues here are not necessarily payroll, although that's our concern in this session. But the main issues become once a business establishes a business connection with the state, it's also subject to the laws of the state and taxes of the state, and in particular the ones that can come into play that are unexpected are income, franchise, sales and use tax, and any other taxes imposed on the business. From a payroll standpoint, the issues are where the employer has nexus. The employer is going to be subject to the withholding laws of that state. And it's an issue because it's possible to accidentally create nexus for a business and then find that you have a situation where you are out of compliance because nexus was established and it wasn't intentional. Anyway, the issues related to payroll then are if you have employees working in the state, that can create nexus, not always, but it can. Employees living in the state but not working in there generally should not establish nexus for the business. But that's a concern also. And then income tax withholding is going to be an issue if nexus is created. Another question would be whether particular employees are going to be covered by SUTA for that particular state, state unemployment insurance, or covered under another state. If you have state residents who are not working in the state but working for you in another state, the question would be whether they're subject to state income tax in their resident state, and whether as a business, the business would want to withhold voluntarily for state residents without creating nexus, or whether acknowledging that would create nexus itself. And of course, the inadvertent creation of nexus is also a major issue with relation to payroll. A colleague of mine stated that before they had anybody that they hired to work in a particular state where they had not already established nexus, or before they had employees go into the state to work, they always checked with legal counsel to see if that would cause the creation of nexus and what they should do to avoid it, or if they should avoid going into the state at all. So, and it's not just employees. It can be something as simple as hiring an independent contractor within the state to perform some business function also. Now, states are not permitted to tax the income of a corporation unless 4 tests are met under the Complete Auto Transit Incorporated versus Brady. This is an old case, but it had to do with interstate commerce. But first of all, there must be a substantial connection or nexus between the taxpayer, that's the corporation, the taxpayer's activities, and the state. The tax must not discriminate against interstate commerce. It must be fairly apportioned. And there must be a fair relationship to the services provided as the basis for the tax that's being charged there. Now, just going through that fairly quickly, the courts have established some particular rules with regard to some of that. Providing services within the state and interstate commerce are issues. The Public Law 86-272, 15 U.S. Code 381 talks about providing services within the state and the relationship to interstate commerce. And what has happened is that the court was called upon to do some interpretation of this, because there was a ruling that a sales call for a sale of tangible personal property in the Northwestern States Portland Cement Company versus Minnesota. The mere solicitation of orders does not create nexus in and of itself. The sales call generally will not. A service call is a completely different matter. If you send somebody in to provide service, or you have warranty service that's being provided to the customer in that state, even if you have independent contractors on call rather than employees to go in and provide those services, that's considered to be doing business within the state under some of this. So under the Portland Cement thing, solicitation, there was solicitation of orders, and they maintained an office located in the state with one or more active salespeople. That can create nexus without, in other words, taking the orders there rather than returning the orders for acceptance to out-of-state location, and filling the order from out-of-state. Just simply soliciting the order will not create nexus generally. So some rules related to state income taxes. Nexus is a difficult issue. There are entire webinars on nexus and other classes and sessions. It's something that you really want to talk with your legal counsel about when there's a concern about whether you do have nexus with a particular state or not, and have them take a look at the situation. Okay, for state income tax purposes, there are some general rules here related to employees, and we're going to define some terms here. The resident state, when I refer to that, and I'll try to use that term each time, this is a state where the employee lives or is domiciled, and that may or may not be a state in which the employee works. The duty state is a state in which the employee works. So that's to distinguish in our terminology which state we're talking about. Now, residence. A resident is subject to the laws of the resident state, including the income tax laws, and most states have a two-tier test related to that. The first test is domicile, and the other test is the time spent within the state. And we'll talk about domicile in a moment on some other, and time spent in the state on some subsequent slides, so I don't want to spend a lot of time on that here. But just bear in mind that these rules vary by state, and there are special rules for military spouses under the MSRRA, Military Spouse Residency Relief Act. Now, prior to that act, the members of the military would retain, as long as they retained their domicile in that state, or they did not change their domicile. Members of the military would be on active duty, would maintain residence in the state where they came from if they were assigned to a base in another state. So for income tax purposes, they retain their original state of residency. Their voter registration would stay in that state, so on. So, for example, if somebody who was a resident of New York went into the military and was assigned to Fort Bragg in North Carolina, they would not be considered a North Carolina resident for state income tax purposes unless they actually moved to North Carolina, changed their residency from New York to North Carolina. They would remain a resident of New York. For a long time, this was not true for military spouses who went along with the spouse in the military to the base. So if our military member was married and the spouse moved to North Carolina with that person in the military, and this person got a job in North Carolina, they would be considered a North Carolina resident under the old rules. Now, under the Military Spouse Residency Relief Act, the military spouse might still be able to retain residency in the state from which they came, despite living in the state where the military spouse